federal judge orders NOPD Superintendent Michelle Woodfork and other city leaders to appear at a court hearing about the federal consent decree.
And as Natasha Robin explains, the court order comes after Mayor Cantrell refused to allow any city employees to attend a public hearing on the consent decree without her permission.
The court gave the city the easy way, and they opted to do it the hard way.
After Mayor LaToya Cantrell said she would not permit any city employees to attend public meetings on the consent decree, the federal judge ordered them to appear in court for a hearing.
We received a subpoena, and we're going to adhere to the subpoena.
Superintendent Michelle Woodfork, among other city leaders, received the order. Federal Judge Susie Morgan wants them to discuss the NOPD's alternative police response as it relates to the consent decree.
The court indicated that if you won't participate in a voluntary hearing, a meeting, we were going to make it be an official court hearing.
So basically the notion that somehow or another anyone other than Judge Morgan thinks that they can control the pace of this is just misplaced.
Mayor Cantrell says the meetings represent a drain on the city, with topics frequently running outside the scope of the consent decree.
Focusing on the consent decree, constitutional policing practices should be the priority. So asking other city leaders, my executive leadership, that are outside of the scope of the consent decree doesn't seem to be that we're focusing on, one, what's at stake here.
The judge is going to make decisions based on facts, but why poke a bear when you don't have to?
Former NOPD Police Chief Ronald Serpez says having to go to court now will cost the city.
But I think what it really costs is trust.
It's going to cost not only more time and effort, but it's also going to cost more money for the city to have to go into court and make this an official court event.
Cantrell, though, says after 10 years under a federal consent decree, she believes the NOPD's met compliance for a self-monitoring phase.
We believe with full certainty that we have met compliance for a self-monitoring phase. My administration has taken the necessary steps, of course, working with the DOJ, issuing a motion to terminate and moving forward in that regard.
The path to substantial compliance is not thumbing your nose at the court. The path to substantial compliance is doubling down and making sure that you've dotted all the I's, crossed all the T's with the consent decree, because that's the only way that it's going to go away.
Natasha Robin, Fox 8, Local First.